are things in your neck of the woods?
Further away you get from Toronto, things become easy. Yeah, it's been very fun.
Yeah, do you mind if I reverse and do presentation tips first? Go ahead. And then CTOs? Just in case I get running out of time on the CTO nitty-gritty.
You're going to argue something that serious physical impairment must apply to brain damage that's caused by schizophrenia.
If we could reconvene, please, ladies and gentlemen. Susan, Reggie, Susan. I'd like to introduce our next three speakers. I'll introduce them in the order in which they're going to speak and then clear out of the way. First, to your right is Susan Opler, Susan received her degree in law from the University of Toronto, was called to the Ontario Bar in 1987. She practiced as a litigator at McCarthy Tatro, and then McCarthy's and McCarthy's. And following hiatus, she became a lawyer member of Ontario's Consent and Capacity Board in November 2001. Since December 2003, she's been a senior lawyer member of the CCB, which means she's entitled to conduct hearings on her own, and is Director of Membership and Legal Services. At the other end of the table, we have Dr. Ranjith Chandrasena, a psychiatrist with the Chatham-Kent Health Alliance. He's the Chief of Psychiatry for the Alliance, an adjunct professor of psychiatry at the University of Western Ontario, academic director of psychiatry for Swarman. I can say it and you'll have to tell us what it is. And an active member of the Consent and Capacity Board since 1983. I just said to me, being a psychiatrist member of the board is a life sentence without availability of parole. And he's just told me that he's also a member of the Ontario Review Board, which you'll hear some discussion of this afternoon. And in the middle, we have Suzan Fraser, who is a principal of a two-lawyer firm in the city, Fraser Barristers and Solicitors, which she established in 2000. The practice of the firm is restricted to the areas of civil litigation and administrative law, with an emphasis on public law and mental health issues, and Susan brings to the panel a wealth of experience in appearing before review boards and courts in connection with issues related to involuntary hospitalization, consent, and capacity. So please join me in welcoming all three of them. And Susan, if you want to.
I've been asked to do two things quickly this morning. One is to review the nitty-gritty of the CTO provisions in the Mental Health Act to provide a context for the discussion that will follow about those provisions. And the second thing I've been asked is to give any tips or word from the board about presenting effectively before the board. I'm going to start with the latter of those two because I'm afraid that time might run out when we get into the nitty-gritty of the CTO provisions. We are very fortunate at the Consent and Capacity Board. We have a number of very capable, knowledgeable, conscientious, dedicated lawyers that appear regularly, quite regularly before us. Unfortunately, however, we also have an imbalance very frequently in our hearings because the applicant, who is the person who is being involuntarily detained or who has been found incapable and wishes to have that challenged, or who is under the CTO, the applicant generally has counsel, and the respondent, which is the health professional who has made the decision in question, generally speaking does not have counsel. So we have an imbalanced situation. And what that leads to is an obligation for us as the board, and I think also for counsel who are present, to take extra steps to ensure that the proceeding is fair. Because, of course, if we hear all the law on one side of an issue from counsel and we don't have in our minds the law on the other side, there's the possibility that unfairness could ensue. So it raises a whole interesting host of issues. Before every hearing that I participate in, and at the beginning of every deliberation that I participate in, I always take out the act that we're dealing with and read aloud with my colleagues on the panel the section that we are applying. Because we're an administrative tribunal, we don't have inherent jurisdiction like a court. We can't hear the evidence and do what's right or do what we feel should happen. We must, by law, apply the legal test that is before us. Period. End of story. So when you are approaching a hearing as counsel, I appreciate that there is a great deal of information, factual stuff, for you to go through. There are often voluminous hospital records, and I believe Dr. Chandrasena is going to help with some tips on how to deal with that. But please don't lose sight of the test that the board will be applying when you present the evidence before us, when you make your submissions of what conclusion we should draw. I find that it's easy to get too caught up in the facts and lose sight of the fundamental question of what is the board here to decide. Please read the test and reread it, and when you're questioning witnesses, only ask questions that will elicit evidence that you will rely on in your argument at the end of the hearing with reference to the test. So evidence in a vacuum is of no use to us. It's a waste of our time, it's a waste of your efforts, and it loses focus. Focus your questioning on the test that the board will be applying at the end. In other words, keep it relevant to what we're there for. And in your submissions as well, I find it surprising personally how infrequently we hear the words of the legal test in submissions. We hear all kinds of other words, paraphrasings, different ways of saying things, but we have to apply the test as it's written. And as I said, at the beginning of our deliberations, we reread that test, and we focus on the words that are there. So it would be much more helpful for your client for you to use those words as well and speak the same language that the Act speaks when tying the evidence to the law and making submissions as to what our conclusion should be. In the materials that you have at tab 4, I've included a couple of things that I hope will be helpful to you. At page 4-28, the board has a website, and if you're unfamiliar with the board's proceedings or appearing for the first time there, you might find that a very useful resource. And as well, our reasons for decision are now available in 2 places. I think selected ones only are at the free website, CanLE, the Canadian Legal Institute, Information Institute, and then also on Quick Law, and I've put the website addresses there as well. So if you're approaching a type of hearing before the Consent and Capacity Board that you're not entirely familiar with, or you want to update yourself on the law, the reasons of the board are available there, and they're cataloged in a way that you can access what you need. And also on that same sheet, I've given you the phone number for Joaquin Zuckerberg. He's the in-house counsel at the board. He can't provide legal advice. He can't tell you how to run the case for your client, but he can be a very useful resource in terms of how board proceedings work, where you might look for resources to help you, what to expect in terms of how the hearing will run, etc. So feel free to call him with those types of issues. Okay, so turning to community treatment orders, as I said, I've been just asked to distill the nuts and bolts provisions of the Mental Health Act to give a context for the rest of the discussion. I've also included at page 4-9 in the materials a sample set of reasons for decision from a decision that I recently was involved in, just so that you know what community treatment order reasons for decision look like. Okay. So CTOs were introduced in 2000 as part of a series of amendments to the Mental Health Act. And really they heralded a significant change in the sense that before CTOs were there was no way legally to ensure that someone took psychiatric medication out of hospital. If somebody was found to require treatment, the only way that they could be required to take it was by bringing them into hospital, treating them, often through the incapacity provisions that you've heard of under the Healthcare Consent Act, and then releasing them. Whoops. Oh, I blew it already. What do I do? Oh, okay. What a CTO is, it's an order. It's called an order, but it's consensual. Somebody has to consent, whether it's the patient, him or herself, or a substitute decision maker. It's an order that a person will receive treatment or care in the community, i.e. outside of hospital. And it's based on a plan, and the plan is a comprehensive plan which outlines any medication, any follow-up appointments, any other support, might include where the person is to live. It's a comprehensive plan for the person to be in the community. And the purpose of a CTO is to keep the person safe and keep the community safe while in a less restrictive environment than being detained in hospital. The purpose is, without limiting the purposes, the stated purpose in the Act is to deal with people who repeatedly stabilize when they go into a psychiatric facility and start taking medication. But then after they leave, they stop taking the treatment, their condition deteriorates to a point where it's dangerous, and then they go back, and this repeats over and over again. So those were the people that they were really targeted for. How a person is placed on a CTO, the team who will be involved, including the person or his or her substitute decision maker, if the person's incapable, work together, they put together the plan, and the Act does prescribe the minimum content of the plan. To qualify for a CTO, a person must have either during the past 3 years been a patient in a psychiatric facility on 2 or more occasions for a total of 30 days or more, or have been previously the subject of a CTO. And also within 72 hours before entering into the CTO, or the community treatment plan, the physician must have examined the person and be of the opinion that he or she is suffering from mental disorder such that he needs continuing treatment and care and supervision in the community. What do I do with this? Sorry. I apologize, I have technical difficulties. There we go. Thank you, I know. Okay. And if the person is living in the community as opposed to in hospital at the time that the CTO is contemplated, they must meet the criteria for the completion of a Form 1, an application for psychiatric assessment under the Mental Health Act. And there has been some case law before the board, and in the courts, in fact, dealing with what this means, that they meet the criteria. Do they have to meet the criteria at that moment? Must there be a risk that they will deteriorate and meet that criteria? Or is the moment, the crystallized moment where that criteria must be present at the time that the board is assessing? And there are cases on that, and that's the type of thing, if you're doing a CTO hearing, you would want to go to the website, the CanLII website, find those cases, and acquaint yourself with those issues. As well, the person must be likely, because of mental disorder, to cause serious bodily harm to him or herself or another person, or suffer substantial mental or physical deterioration, or suffer serious physical impairment if they do not receive continuing treatment or care and continuing supervision in the community. The practical requirements under the Act are the person must be able to comply. That is not the same as willing to comply. And the things prescribed in the treatment plan must be available in the community. Every CTO, as I said, requires consent, so although it's called an order, it's actually consensual. If the person is capable to give consent for him or herself, it must be informed consent. And if not, the substitute decision maker must consent, and must do so in accordance with the provisions that Cynthia made reference to briefly. The Healthcare Consent Act sets out the principles for substitute decision makers making decisions on other people's behalf. And those must have been followed and must be shown to have been followed by a substitute decision maker when consenting to a community treatment plan. There's a requirement for rights advice to the person and the substitute decision maker. CTOs last for 6 months unless they're renewed or unless they're terminated before that time. And they can be renewed for 6 months any time before they expire and within 1 month after their expiry. There's also a legal issue out there about what happens if it expires and it isn't renewed for more than a month. Is it a late renewal or is it a new CTO, and what flows from that? Anyone in respect of whom a CTO has been signed has a right to apply to the board, the Consent and Capacity Board, which I'm a member of, to inquire whether the criteria for a CTO are met as of the date of the hearing. And every second time that a CTO is renewed, there is an automatic deemed application which can't be waived by the person. So the board must review a CTO every second time it's renewed. Where the board finds that the criteria are met at the time of the hearing, we may confirm it. Where we find that the criteria are not met, we must revoke it. So the legislature has given room for some discretion where the panel might find that the criteria are met, but that for some other reason we don't wish to confirm it. However, we must revoke if the criteria are not made out. And the onus of proof in these matters, just as in consent matters and involuntary status matters, doesn't lie with the applicant. Normally, as lawyers, we think that whoever's applying has the onus of proof. In these matters, it's reversed. The applicant is generally the person subjected to the restriction or the limitation, and the onus of proof lies with the health practitioner, the physician, who is seeking to impose the restriction. So if it's involuntary status, the doctor has the onus of proving that the legal criteria are met. And if it's a CTO, the physician who signed the CTO has the onus of proving that all of these technical steps were taken and that the legal criteria for the CTO are met. The CCB can revoke the CTO, as I said. There's also provision in the Mental Health Act for other ways in which CTOs can be terminated. There's something called an order for examination, a Form 47, where a physician has reasonable cause to believe that someone has failed to comply with his or her obligations under the CTO. They can issue an order for examination, which means that the person will be brought back. The person must still meet the criteria, and there must have been reasonable efforts made to inform the person or their substitute decision maker of the fact that they have not been complying and of the consequences of not doing so. The order authorizes the police for 30 days to find the person and to bring them into custody for the purpose of being assessed. Okay. And once the person's brought in, that physician must promptly assess them, determine whether a Form 1 is required. That's the application for psychiatric assessment, or whether another CTO should be issued, or whether the person is able to be released without a CTO. Another scenario that has occurred and that has been the subject of board hearings is not a Form 47, but simply a Form 1. So there wasn't an issue of finding the person and bringing them, but the physician has become concerned, or some other member of the treatment team has become concerned that the CTO is not having its desired effect and that the person meets the criteria for an assessment for psychiatric assessment. So the person has been detained under a Form 1, and the board has been asked to decide whether that event terminates the CTO. And in the decisions that I'm aware of, the general view has been of the board that it does not, and that the CTO continues despite the Form 1, but it's certainly a live issue until the courts tell us the law. A person can also withdraw consent to a CTO if they're consenting to their own CTO, or a substitute decision maker can withdraw consent. And then the physician reviews the person's condition and things follow from there. So as I said, I've tried to summarize very succinctly what are really a very complicated and technical set of provisions. If you're doing a CTO hearing, or if you're contemplating a CTO on behalf of a client, please do look at the provisions in the Act carefully. There's a couple of big questions, lots of small questions and various types of questions outstanding about CTOs. There's two very big questions still outstanding that I'm hoping we will have answers to shortly. One of them is whether the CTO provisions can withstand scrutiny under the Charter. And Suzan Fraser has begun what may be a long process of a constitutional challenge to those provisions. She's going to tell you about that in a minute. And we're hoping that we'll get at least some guidance on that from the courts in the reasonably near future. And the second question that I feel is really important and needs to be addressed is whether CTOs are working, We've had them now for close to 4 years. Are they working for patients? Are they working from the point of view of the physicians and other health professionals using them? Are they working from the point of view of family members? When the amendments were brought in, there was contemplated a review of these issues. It's in the legislation and has just been announced that it's going to start getting underway. Michael Bay, who is a former chair of the Consent and Capacity Board, and David Hoff, who's a current member of the board, together with some consultants, will be trying to get answers to these questions. Even the record keeping of how many people are under a CTO at a given time in Ontario is very hard to get a hold of. So they're going to be doing a comprehensive review of CTOs and how they've worked and where the shortcomings may be and where we should go from here. And I've included in the materials as well the website for their project. It's called the Ontario CTO Project. They have a website, and they will be seeking and encouraging input from anyone with anything to say on the subject. Okay, so I think that's it. Thank you very much.
Morning, everyone. I'm just going to get this presentation on. Well, if I move around, will you have a difficult time hearing me? Because I'm not used to sitting behind a podium. Let me tell you what I do while we get this thing on. I'm a psychiatrist, and a psychiatrist is someone, and I'll try to express this to you. There was this person who was out on the street who was kind of doing this, and the policeman walks up and asks, "What are you doing?" He said, "I'm a sculptor." So he says, "Okay, well, who am I sculpturing?" As a policeman. "Okay, what are you using to sculpture to do this?" He said, "I'm using BS." The policeman wasn't too pleased and takes him to the courts, and next day he's before a judge, and you're going to hear all about NCRs this afternoon. And he's out there doing that, and the judge asks, "What are you doing?" "I'm sculpturing." "What are you sculpturing?" "A judge." And he says, "What are you using?" He says, "I'm using BS." Judge wasn't too pleased. Said, "Get the guy seen by a psychiatrist." So the psychiatrist walks in next day to the prison, and of course, psychiatrist walks in, the person's going like this, and he says, "Oh, you're sculpturing." He said, "How did you know that?" "I'm a psychiatrist, I know of everything." Then he says, "Oh, well," he's going like this, "You're sculpturing, you're using BS." He said, "Gosh, how did you know that?" "I'm a psychiatrist, I know everything." Then he says, "I think you're sculpturing a psychiatrist." He says, "Doctor, that's where you're wrong, because you all never have enough BS for that." So with that in mind, here you are. You are lawyers, and you're going to go into some uncharted territories in a way, like these birds, some turbulent waters, because you're going to come into my arena where I practice, and which is medicine. And you're going to have to learn to try to understand, just as much as if I went to court of law, I better figure out what is the difference between an exhibit and a document and an affidavit. Just like that, you're going to have to understand some of these things we do as psychiatrists. And my job today really is to try to give you a quick overview and to give you some tips how to navigate. First, some definitions. What's a clinical record? A clinical record is defined under the Mental Health Act. It's on Section 35(1). I won't read this to you, but you just have to get some idea of what a clinical record is, and you know these things better than I do because you are lawyers. For us, it's something that's blue and sticks around in the hospital. They look like this. Right? That's a clinical record. Now, I want to prove to you that beauty is skin deep, and it does look like this. Now, it looks well organized, admission records, history, all those things. Now, you get in there, well, it's not too bad, is it? You know, there is this consultation report, it's typed, you can read it, and actually there is a note that's handwritten. I know that it's not from a doctor because it's actually legible. So, now it's getting a little bit more complex, and this is something that you have to contend with. Computerized records. You're going to find that in many hospitals you go to, you're going to have computerized records, and you're going to have to find your way to navigate them. It's, you're going to find information that are summarized, and there are going to be keys to get into more information, and you're not going to find the kind of nurses' notes and things that are there, and there's going to be less and less of that, and over the years. Eventually, the physicians will also be doing computerized record keeping. That probably is 5 to 10 years away, but it's something that's coming. What's more important is that charting by exception. That is to say that unless the patient's dead, you don't have to say that they're alive. So it's taken for granted that the person's alive. Just like that, if the patient's suicidal, it's recorded, but if it is not recorded, it is, no, the patient's not suicidal. It's charting by exception. So it's going to be very summarized, and it is point form, and then you can write detailed notes in a different format, and unless you know how to access them, you won't see it. And that too is often in about 200 characters, so it's very succinct. And those detailed notes that you're used to in health records is going to be something of the past in time. So they're going to look like this. Now, that's the actual clinical record, but then these patients have often been in hospital before. Do you need all clinical records? Now, how do they look? This is how they look. This is true. This is, I took this picture last week, and this is no different. And it's tucked away in some corner. Don't assume that these are going to be there. Unless the doctor has ordered them for their purposes, they wouldn't be in the medical records. And once you open that one, what does that look? It looks like this. You okay, because court documents and all those things look the same to me. How do you navigate through this to gather information so that you can assist your client and represent them before the CCB? Now, these patients don't only come to hospital, stay in hospital. They actually get looked after by psychiatrists, often in the psychiatrist offices. And it's not even a psychiatric facility. What do they look like? They look like this very often. And that's the writing. And this actually is a good doctor because you can read some of it. And remember that doctors don't write notes so that lawyers can read them. We write notes so that we can actually communicate to colleagues. The only time a doctor writes detailed and copious notes is when they have done something wrong. So sources of clinical information you have to go to the clinical record. There are past clinical records. Unless you don't ask, you won't get it. There are outpatient clinical records that are not part of the hospital. Particularly for a CTO, you may need that, and you may need the assertive clinical treatment team record, that's called the ACT, because you need to find out what's going on with that team. There is the psychiatrist's office records, which is not a psychiatric facility, but they would have useful information. Then there's the family practitioner records. You should never have access, and they may be relevant for SDM, for prior expressed living wishes, all those things, these may be relevant. And of course, there is policy manual and the black book and shift tapes. Let me tell you a few things about the policy manual. We saw a patient as a member of the Consent and Capacity Board the other day, 40-odd-year-old lady who thought that Her Majesty in England had given her inheritance, and the usual things that we hear. Seemed like a sweet old lady who was there, but the history that was presented was that this patient was been in seclusion about 4 or 5 times. Didn't quite come through that way. Trying to find out why she was in seclusion, I asked, what is the policy on your patients going into seclusion? Because she has been escorted to the seclusion room 3 or 4 times by the security. Then they said that the nurses interpret restraint in the narrowest sense. They do not ask someone to go into a seclusion room. They always call security up. And they do put them in seclusion and keep the door open. It's not really seclusion as the seclusion sense, but it's a kind of a quiet room. But when the evidence is presented, unless you know what the hospital policies are, it sounds like somebody was in seclusion and was escorted by the hospital security. Sounds very serious. So you need to know that. What is the black book and the shift tapes? No psychiatrist in here, right? I can share some secrets, because this is not something that psychiatrists or the doctors want you to know. There are all kinds of interesting things that are written down that are never part of the chart. Now, if you want to make a living out of suing doctors. I hear that it's not a bad thing, bad living either. Really, there are things that nurses write down when they hand over information from one shift to the other. All the interesting things get written down there. It's the same by way of tapes. You dictate what happened during that shift, and it goes to the next shift. And they are erased, particularly if the patient go to the operating room and comes after amputation of the wrong leg. These are things that does happen in hospitals, and it is not considered part of the clinical record. So what are the challenges that you're going to be faced? How to work through a chart? You see, the thing is that if I look at a legal document, I'm lost most of the time because it's written in legalese. Just as much as you are when you read through a chart. It's written in medicalese, I suppose. And we also make it worse by writing things in Latin, QHS, PRN. What do they mean? SOB, not what you are thinking. It's shortness of breath. So these are the things that we write and think. So unless you know them, you would have a hard time understanding and putting things in context. The easiest way, and this is, I'm not kidding, to find out what it is that we do is to find out a physician that you know, take them out for lunch or dinner, and just spend half an hour and ask them, what do these things mean? You'll learn a lot, because it will help you understand that. It's amazing what we'll do for a free meal. Obtaining all relevant records is not easy, because you come in there, you look at a chart, it may be relevant for you to get the old records, but they may not be up on the floor. So you have to get them. Reading the chart and obtaining relevant information is difficult because it's all over the place, and we often know where to go for our purposes, but you have a legal purpose, and you have to read through everything and now computerize. New challenges. We are in the making the healthcare system more efficient. That's why it's costing more money. Now, we have these ICU, intensive care units. It's called PICU, psychiatric intensive care units. And often the patients stay there for 2 weeks, and they get transferred to what would call a step down or a progressive care. Another hospital, different set of people, 2 charts. What do these things mean? We're not quite sure, but often the chart does not follow to the other hospital. So you may not have the information, and if you want that, you have to get them ahead of time. We talked about computerized records. So with this in mind, how can you gather information if you're going before a consent and capacity board? First, start off at the beginning. Usual contact for a psychiatric patient is the emergency room, doctor's record. Doesn't tell you much because it's going to be focused more on the physical things, but it will at least tell you why the patient came there. Most hospitals are now having psychiatric triage nurses. If any of you have been to an emergency room, you know that a nurse will decide whether you need to be seen now or tomorrow morning, and that's called triaging, if it is not serious enough. So they keep you waiting based on. It's not a first come, first served basis. Often when they see a psychiatric problem, they have a psychiatric nurse who will triage, and they write detailed notes. So go to the psychiatrist nurse. The difference between a doctor's note and a nurse's note is doctors write opinions. We say that the patient is psychotic, suicidal, violent. Doesn't matter what led to the opinion, but that is our opinion. Nurses actually write things such as the patient was coming frequently to the nurse's station and would not go back to the ward, and when I said that they cannot smoke on the corridor, told me that my parents weren't married before I was born. So they write detailed behavior. So it is important because that's the evidence to support your conclusion. Now, if the doctor writes the patient suicidal, if you want to look at the nurse's notes, if you have to go into a computerized record and navigate through, it's going to take time. And you have to know how. Ambulance records, nursing home transfer notes, JP's orders, affidavits, they're very useful for your purpose, because that's where what happened and what brought the person to hospital and what happened thereon, and it's in the chart. Physicians' progress notes, nurses' notes. Social work, they're very good at writing things about family, prior expressed living wills, all those things, they are the ones who usually take information. Occupational therapy assessment, they are the ones who do the things about financial incapacity. So they're very good, and you need to know where to zero in, because otherwise you're going to be thumbing through a lot of paper trying to gather information. Seclusion and PRN record. PRN means as and when necessary. Seclusion, by hospital policies, you need to write down what led to the seclusion, how long they were there, how long they were observed for, and these records are often kept in a different book. And a PRN records are not part of necessarily the medication orders. So you need to know that there may be, when you look at a medical record, it may look like this, but there may be 5 other things that are separate that constitute a whole other record. So, survival guide, first thing is time. Don't turn up to see your client 1 hour before a consent and capacity board hearing and think that you're going to get it through. You're going to need a lot more time, even for the simplest of cases. Second thing is that inform ahead of time of your arrival. Very simple, because if you turn up without telling, don't assume that the patient or your client is going to be there. The patient may be at a CT, maybe having a barium enema. You really won't want to see them after that. Or they may be with a doctor. They are not going to let, the chart may be with a medical student who is writing notes. So you may not have access to that. So inform that I am coming at a particular time. Can you please make sure that my client is going to be available and the chart is there? They will do it. Request the information through the ward clerk and medical records department. Most larger hospitals where there are consent and capacity board hearings, there is a system. They work for the most part. When you're going to new places, there may not be a system. You may be going to a nursing home. You may be going to different places where consent and capacity board hearings are like an eclipse that happens every now and then, and they have no idea. So plan for the whole day if need be. Be prepared to pay and wait for photocopies. There's nothing in the Mental Health Act, and I'll tell you, I've read it a few times, that says that you have to provide photocopies promptly. It's only rights advice that has to be given promptly, not photocopies. So, if you want this much to be photocopied, no ward clerk is going to run around and photocopy it for you because you got to get back to your office. And there's nothing in the legislation that says that you can't be charged for it. Somebody's got to pick up the cost. So be prepared to do that. You know, psychiatrists don't bite. Talk to them. They're usually very good at giving you information that you need, but they shouldn't be telling you. Ask them, what are the reasons for certification? Why is the patient suicidal? They will tell you. Then you can prepare your case, and it actually helps the psychiatrist. And I tell often the psychiatrists, when I give the talk to them, the lawyers don't bite either. Why don't you just talk to them? They'll tell you what their case is going to be, and then you can get the evidence, or more often than not, realize that actually this doesn't meet the test. Maybe what the patient requires actually is more privileges. There are simple things. Talk to each other. Be nice. 99.9% of the lawyers, just like 99.9% of the psychiatrists, are nice people. They have good manners. But we all remember that 0.1% who had the social skills and the professional skills of a rhinoceros. So the next time your colleague turns up, they remember the one who turned up and was difficult, demanding, wanting this, that, and the other. You're not going to get much. Because the ward clerks, the nurses, everybody are there to do a different job. So if you want them to do things, being nice really does go, and the ward clerk and the medical records are the people who are going to make your life much easier. Now, I'm going to pose some questions because there's you will not get an opportunity. When I look around and I see the people and the wealth of experience, both from consent and capacity board coming before as lawyers, Darcy, Anita, and all the people here, you'll never get a chance like this to pick their brain. And I'm going to pose some questions because there may be different views, and depending on which side you are representing, they may be helpful. Accessing a patient's chart, you are the lawyer, you turn up. They say, oh, you can't let you see it unless the patient signs a Form 14. Patient won't sign a Form 14. Now what are you going to do? Now, Is it necessary to have a Form 14 when you're representing somebody? I'm going to leave the question. I think that answer is fairly straightforward, but these are the kinds of questions that you have to ask. Or should we tell them? Maybe I'll ask somebody in the audience to give the answer after. Psychiatrist in the office chart, do you need a Form 14 to get that chart information? Is that, what happens if the psychiatrist says, no, I won't release the information unless you give me a Form 14 and pay for the thing? Under the Mental Health Act, you can prevent access to clinical records of a patient. It's under Section 36. It says that if you're likely to cause serious emotional or physical harm to yourself or someone else, it's sort of worded in legalese, you can deny. Does that mean that if you're representing the patient, your client, you have access to the chart? Now, if you have access to the chart, then ethically and legally and morally, can you deny the information that you know to your client? Now, these might be the kind of things that you want to debate and discuss because these are things that come up and they have been discussed before. I was asked also to identify some hot button issues which I think that as lawyers who are going to come before the Consent and Capacity Board, things. Look for inconsistencies or the apparent ones in the chart. What it means is that essentially if a patient is suicidal and that's why they're on a Form 3, how come they were on weekend leave? Now, it is possible, but those are the kinds of things to zero in. Is the patient voluntary or not? You might get a feel for that, and I'm sure Darcy is going to talk about some of these things when they came in through the emergency. What happened after the Form 1 lapsed and the Form 3 started 2 days later? Was there any documentation? What's this thing about certifiable if attempting to leave? What does that leave the patient with? Is that still voluntary, informal, or some limbo where you should be calling a Canadian Medical Protective Association if you're going to write that kind of order? Rights advice, promptly. What does that mean if you don't have a rights advisor and if it is a Thursday evening at 5:30 that you certify the patient and the rights advisor sees the patient on Tuesday morning at 8:30. Friday is Good Friday, Monday is Easter Monday. Is the advice promptly? Now, that's the capacity assessment for treatment. And if you're going to represent a patient about capacity for treatment, see whether the doctor has actually talked about the treatment, made some documentation about the side effects, and because how can you assess a capacity if the patient has not been told the information? Evidence versus opinion we talked about. Some interesting things, financial capacity. It says forthwith you have to do an assessment. Doesn't get done, but what does forthwith mean for every patient who turns up in the ward? So if it is a financial capacity issue, if it hadn't been done forthwith, whatever that means, is the assessment invalid? These are some interesting questions, and I'm hoping that the panels will take these issues up for discussion. So now, I hope I've given you some idea of how to navigate through some of the troubling waters in hospital and go in there. And I'm going to stop there, and I thank you for your attention.
I was listening carefully this morning when Arthur said he's always reminded of the bar admission course, and for some of us that's a more recent memory than others. And I wanted to introduce to you somebody who I think is probably very efficient. He managed to get called to the bar this morning and come to his first continuing legal education seminar today, and it's his intention to practice law. He practices in the building that I practice in. His name is Johnson Babalola. He's in the back corner. So. I think I've embarrassed him sufficiently, but he has been practicing in the area of law, not as a lawyer, and I think he'll make a tremendous contribution. Several weeks ago, I went to Boston, and I'd like to say that I sort of kicked off their run to the World Series. I'm wearing the outfit that I got in Boston in honor of their victory last night. But when I was there, my girlfriends and I went on what is called the Freedom Trail. And the Freedom Trail in Boston marks all of the significant places where the patriots were and where the birth of notions of freedom and liberty came and sort of formed in the American Constitution. When you go on the Freedom Trail, you're taken by one of the patriots dressed up in patriot garb. And our patriot who guided us was a fellow named James Otis, in the character of James Otis, one of the original patriots. James Otis was a lawyer who in his time challenged what were called writs of assistance and had successfully abolished them. I think we had them in Canada till the early 70s. But he was a very successful patriot and coined the phrase, taxation without representation is tyranny. And I tell all of this to you because at a certain point in his life, James Otis started running around half naked. And he was eventually locked up in asylums. And it's interesting to me because I said to the James Otis who was in character, well, it sounds to me that, I think we would have medicated him in these days. He said, oh yeah, they now say that he was likely bipolar. And even the times where he was very successful in terms of his litigation, he was made fun of by his colleagues and the other patriots as somebody who was odd. But yet he had this brilliance and these ideas that maybe today in our times we would have seen as an aberration and tried to even out. So it's interesting for me, and I always approach these issues with the notions of when our clients are saying things that are out of the ordinary, where does put that in the perspective of a sort of a broader understanding of humanity and human problems. The paper that I have included in the materials and that was prepared with Jean Bowie, Jean was fundamental in terms of driving the issue of the charter before the board, and in preparing the paper, deals comprehensively with the issues of the charter and the consent and capacity board. And we have identified that as a sort of hot button topic because what we are finding in terms of the community treatment orders is that they are regularly confirmed, that the challenges before the boards are essentially unsuccessful unless there are technical grounds. And what I advise my clients is it is very unlikely that they will succeed before the board unless the court eventually finds that the legislation infringes their charter rights. And there are two essential problems or three problems as I see it with the legislation in terms of the challenges and why council are having such a hard time defeating community treatment orders, even when they're on their fourth and fifth renewal and there's been no signs of deterioration in the community. And those problems, as I see them, is that the purposes section of the Act, when the legislation was introduced, one of the things that was said was this legislation was targeted at a very discrete community, a revolving door patient, and the purposes section is inclined to deal with that. And it talks about the purpose of a community treatment order and the type of person. And when it describes the type of person, it gives somebody who goes into the hospital, is treated, is released into the community, deteriorates, and has to be readmitted and experiences this pattern. The only problem with that description in the legislation is that it says, without limiting the generality of the foregoing, and then it goes into this great description. So when you bring this to the board's attention, they generally say, well, we can't rely on that revolving door description because of the without limiting the generality of the foregoing. So that argument that a community treatment order is targeted to a specific group of people is really has failed. That this is only something that ought to be applied to somebody who has been a revolving door patient has failed. So we see much broader application than we would have otherwise seen. The next two issues that I see is that the board regularly confirms community treatment orders for people who are incapable and who meet the criteria not of what is the traditional certification criteria, but who meet the new application for psychiatric assessment criteria, which, if you look at it, is based on the person being incapable and having received treatment in the past and improving on that treatment. So even though the person is basically well, the board says, well, they're well because they are on the order. And so you can have people who are on community treatment orders who have had no significant disturbances in their mental health, their psychiatrist would say because they are medicated, yet and so they're on the community treatment, no disturbances, yet they will be maintained on a community treatment order, even when there's no risk to society or themselves. But the danger is that they will go off their medication. So these are really where the difficulties lie in the actual challenge to the CTO on the criteria. I just want to take you through a few tips in terms of starting, if you're doing a CTO challenge, to start early, to determine whether your client wants to challenge. This is the value-added bonus. It's not actually in the paper, but to start early, to determine whether your client wishes to challenge the legislation. Many clients don't want to. They want the process to be over with. So while they want to participate in it, they don't want it to be something that's going to carry on. So you will sometimes see clients who do not wish to raise a challenge to the legislation. If they do, you'll have to serve your notice of constitutional question in accordance with Section 109 of the Courts of Justice Act. You will need to amass the evidence, and you've just had an excellent talk in terms of the types of records that you should be looking for, and also looking at collateral sources. I just want to talk very briefly now about the status of the challenges to the CTO provisions. A number of years ago, when the first CTOs were issued under the legislation, Anita Seghetti served a notice of constitutional question and in a case called ACE-SH, and argued it before a panel of 5, one of whom is now her partner in law. And the board at that time found that it did not have the jurisdiction to consider the constitutionality of its own enabling legislation. And the law of the land at that time was a case called Cooper. And Cooper was a case decided by the Supreme Court of Canada, which limited the ability of tribunals to consider the constitutionality of its own enabling legislation. And it did so on a distinction between whether the tribunal had the ability to consider general questions of law or specific questions of law. And if it didn't have the ability to consider general questions of law, it was found not to have the ability to consider the constitutionality of its own enabling legislation. And in that case, Madam Justice McLaughlin, who now is the Chief Justice, and she said the charter is not something that's only available to the judges. The charter is for the people. It's not some holy grail that is to be held up. And all lawmakers ought to be subject to it. And what we see in the thrust of her decision, which has now become the law through the new a case called Martin, and just going back to Anita's case in SH, Anita argued, even though Cooper, that what we really should be looking at is a small case out of Nova Scotia from a human rights tribunal there, and that argument was essentially mocked by the Attorney General, who obviously could not know at the time that it would become the law of the land in this country. But it was an interesting turn of events that Anita was relying on a different approach that would later become the law of the land. Martin basically, what I say, gives the charter back to the people. That it says, of course, tribunals have to consider the constitutionality of their legislation when they have the ability to consider any question of law. Any question of law. So the distinction between this general and specific is now gone by the wayside. And so what it means for the Consent and Capacity Board, we have litigated this issue in a case that's now called Jane Patient. It is expected to be heard by the Divisional Court on December the 17th. And in Jane Patient, I'm not going to give you the name of the case as it was argued before the board, because my clients, although the board has used initials, I don't want to my client wants as much anonymity as possible within the process, which is why we went by the name Jane Patient, even to get away from any identifying initials. I've asked the board to produce a copy of that decision in the name of Jane Patient, but it will not. It will only use the initials. If you want a copy of it, so you'll have to track it down on your own, essentially. I'm not going to give it to you, or you can wait for the divisional court to rule on it. In any event, in that case, the board found that it did have jurisdiction to consider the constitutionality of its legislation. It rejected the argument of the Ministry of the Attorney General, which intervened on the case, which said basically the board's job is really to check off the boxes and to see that these criteria are met, that they don't have the ability to consider questions of law, that their job is really a fact-finding mission. And for those of us who appear regularly before the board, this is completely at odds with our understanding of the board, which really, as practitioners before the board, we see the job of the board is to determine whether a detention is legal, to determine whether an individual is legally capable. And for them to say that it really is a fact-finding mission, I think is an affront. And if it is an argument that is accepted by the court, in my view, it means that the Consent and Capacity Board will have to come to an end. And the reason I say that is if there is a system of detention and a system of review in this province where for a class of persons the charter is unavailable, that sets up a system that is unequal to another system of review that we see in the criminal courts, where people can advance their charter rights in the first available forum, in the most accessible manner. And so, I think the logical conclusion, if this board doesn't have the ability to consider the constitutionality of the laws it has to apply, or to give remedies that would be otherwise available in another forum. And that's another question that we didn't litigate, but the question of whether the board can give remedies is alive and out there. But how can we have a system for a whole class of our population where the charter is out of reach? So one of the emerging ideas that we will be saying to the court is if this board does not have access to the charter, then this system cannot continue to function. And I think it's a very real issue and an issue of a grave concern. We need to have a forum where our clients' rights can be argued fully. The paper comprehensively deals with the case, and so what I want to just in the last remaining bit of time that I have is to just deal with some trends that I see in terms of the community treatment order litigation. We see a role that physicians are increasingly becoming what I would call state actors. Traditionally, physicians have been very independent, both of hospitals, of the government, but more and more they're being called upon to enforce a model of protection for individuals and societies, and they're doing it through legislation. And I say that that elevates physicians to becoming state actors, because as we see more and more, rather than making medical treatment decisions, they're taking a role of social control that is really unprecedented. And it is a role that they didn't ask for, I don't think. They asked for legislation, but the whole role has been thrust upon physicians. And really, from my view, it's a question of how long it can be sustained. We don't see clients who we would say are clients who are having our most difficulties actually getting on community treatment orders, or any attempt for physicians to put the clients who we see are most in need on community treatment orders. Rather, what we see in our office is people who have very active families being placed on community treatment orders. People who have no families or who are isolated from their families generally do not get placed on a community treatment order. We see community treatment orders where the clients have to pay for the medication. The medication is ordered, there's no drug plan. I have one client who was ordered to take Zyprexa under a community treatment order at a cost of $200 a month because her family status is such that they don't have any drug benefits under a welfare system. We're used to a system where we see people with mental health problems being impoverished as well as having mental health problems and getting benefits. But for the middle class person with mental health problems on a community treatment order, the drug costs are astronomical. What we don't see is we don't see community treatment orders incorporating the elements that consumers and survivors have seen as being essential components to their recovery: a friend, a job, a home. I see many, many community treatment orders where there are no good provisions for housing and no good reintegration in the community in terms of social supports like Progress Place. And finally, what I see as a very disturbing thing is that social workers are increasingly becoming, doing less social work and more social control, or rather monitoring people on a community treatment order to see compliance with the order rather than advocating for services for an individual. So what I would like to see is I'd like to see more liberty. I'd like to see more liberty up front, and I'd like to see physicians, active and social workers, and all of the people who are creating community treatment orders spend some more time on the self-identified needs of the individual and hearing the voice of the people who are subject to the mental health system.
Thank you, and if you join me, please, in thanking all three members of our panel. One of our goals in putting the panels together was to ensure that we brought a variety of perspectives and bodies of knowledge to bear on each of the issues that we brought forward, and this panel has certainly succeeded in fulfilling that mandate, for which I thank you. And if I could ask you folks now to leave the podium, clear out, and our next two speakers to come forward, and perhaps if we could have some assistance getting the PowerPoint presentations up and running. Not for you. Let me introduce our Ain't Technology Grand? Let me introduce our next two speakers. There's an old adage, if you want something done, ask somebody busy to do it for you. And I'll say in Dr. Hawryluck's case, if you want something done, ask somebody who's outrageously busy and has absolutely no time to do it for you, and probably no sleep, and see how things get done. So, as you can see, we organized today also so that once we had laid out the basic concepts for you, we're going to move as the day progresses through the application of those concepts to particular aspects of practice. And the issue we're now going to address is end-of-life decision-making, which I know I find in my own practice is increasingly giving rise to problematic cases and also to litigation. And here to help us grapple with those issues are to the right, Erica Barron, who is an associate in the litigation department at McCarthy Tatro. Erica was called to the bar in 2002. She's a graduate of the University of Ottawa and a graduate of the University of Western Ontario. She carries on a general litigation practice with a focus on medical malpractice, and she has a particular focus and interest in estates and trust litigation. Dr. Laura Hawryluck received her MD in 1992 from the University of Western Ontario, where she also served her internal medicine residency. She completed a fellowship in critical care in Manitoba, received a Master's of Science in Bioethics from the Joint Centre for Bioethics at the University of Toronto. 1999 to 2001 was an assistant professor of critical care and internal medicine at Queen's. In March 2000, she was appointed the physician leader of the National Ian Anderson Continuing Education Program in End-of-Life Care at the University of Toronto, and in that connection has been awarded the Queen's Golden Jubilee Medal for her contributions to Canada. Please join me in welcoming them both. Erica?
Before I start, there is one small error, but nonetheless significant one in the paper, and I just wanted to draw it to your attention. On the last page of the paper, which is 719, I believe, 18, sorry. In the second line, the word not is missing from right after do, which obviously completely changes the meaning of that sentence, so you just might want to make a note of that. The second line. Right in the middle of the second line. Instead of do, it should be do not. I'm going to start by briefly reviewing the facts of the Holland case, which are set out in a fair bit of detail in the paper, and you also have the Consent and Capacity Board's decision in that case and the Supreme Court, the Superior Court's decision. The Consent and Capacity Board's decision is in tab 7, the Superior Court decision is in tab 8, and they both make quite interesting reading, and we'll set out the facts in a bit more detail. But in order to understand the issues that arose in the case, I think it's important to have an understanding of the facts underlying the decisions that arose in that case. It involved an 81-year-old woman whose name was Mrs. Holland, and she was 81 at the time of the Consent and Capacity Board hearing, and she had Alzheimer's disease. And her condition had been deteriorating for some time, and she'd been in a nursing home for approximately 2 years before she was admitted to the hospital. Because of her Alzheimer's disease, she had begun to aspirate, which is instead of swallowing, you actually breathe fluids into your lungs. And as a result of that, eventually developed pneumonia, and that's really what had prompted her admission to the hospital from the nursing home. She was in the hospital for a while and eventually had to be admitted to the ICU and was placed on a ventilator, was given drugs to keep her blood pressure at an appropriate level. And during her time at the hospital, she was twice admitted to the ICU. So she was admitted for a period. Eventually they were able to wean her off the ventilator and return her to the internal medicine ward. Then she had a deterioration, had to be readmitted. And each time she was readmitted to the ICU, her baseline condition would deteriorate further, and she'd also have a longer period of time on the ventilator. The more time you spend on the ventilator, the harder it is to get off of it, because eventually your body starts to rely on it more. And those treatments, and Dr. Hawryluck will talk about this a little bit more, the treatments that you receive in the ICU they're not benign, they're uncomfortable for the patient, and it's difficult with a patient like this who has serious neurological diseases to be able to appreciate whether or not there's effective pain management with the patient, because there isn't a lot of communication that can happen about that. In addition to the neurological problems that Mrs. Holland had, she also had a number of physical problems because she was primarily bedridden. So she had bed sores, flexion contractions, which is when your joints are permanently bent so you can't move them anymore. And there was no dispute amongst the parties that she didn't have capacity to make treatment decisions for herself. There was some dispute between the doctors, the medical team, and the family members about how aware she was of her surroundings. The doctors couldn't appreciate any real response to external stimuli of any sort, that she wasn't recognizing the doctors' voices. The family members said that they noticed more response from Mrs. Holland than the medical team did. And so After the second admission to the ICU, the medical team was quite concerned about continuing to provide this intensive medical intervention to Mrs. Holland, but there was a recognition that if she wasn't returned to the ICU the next time, her physical condition deteriorated. In all likelihood, she would die because she would need the ventilator to keep breathing. And so the medical team spoke with the family and said that they didn't want to return. It was their view that it wasn't in her best interest for her to be returned to the ICU, and the family was quite insistent that she be returned to the ICU. And so that's how the dispute crystallized. And so the medical team decided to go to the board and ask for the board's ruling, the Consent and Capacity Board's ruling, about whether the daughters in this case, who are her substitute decision makers, were acting in her best interests under Section 21 of the Healthcare Consent Act. And at that hearing, the board did give the medical team permission to withdraw or withhold these treatments, and in particular, the ventilatory and the treatment for the blood pressure problems. And that decision was appealed to the Superior Court of Justice, and the decision was set aside, the board's decision was set aside on a number of grounds that I will get to, but it was set aside without prejudice to the ability of the medical team to return to the board and address some of the failings in the first decision of the board, or if circumstances changed with the patient. And so it's still a possibility in that case, and indeed in all cases, that even if the decision of the board is set aside on certain grounds, there is a possibility to often go back to the board and ask again if things have changed. And now I just want to turn to some of the interesting legal questions that were raised by the decision. There were a number of things that are actually decided by the Superior Court's decision in this case, but in fact, the interesting questions are the things that were left open by the case, because there are a lot of question marks that the case raises and leaves open to be determined in another case. First of all, there is an interesting, if you look at the treatment of definition in the Healthcare Consent Act, and it was gone over earlier, but it's very interesting because normally we think of the word treatment as being something positive as opposed to an omission like withdrawing or withholding treatment. But because of the way treatment is defined in the Healthcare Consent Act, treatment is defined to include the definition of plan of treatment, and plan of treatment actually references withholding or withdrawing treatment. And so we're left with a definition of treatment that actually includes not only positive provision of treatment, but also withholding or withdrawing treatment in certain circumstances. And there is a provision saying that you can't provide treatment without consent. And so the question is, well, does that mean that if you can't provide treatment without consent, then it means you can't withhold treatment without consent? And does that then translate into a positive obligation on doctors to treat? That any patient or any family member who's acting on patient's behalf can come in and say, we want this treatment for our patient, for our mother or father or sister or brother, and the doctor has no choice but to provide it because of the definitions in the Act. That question wasn't actually decided by the decision in this case, and the reason it wasn't decided was because it didn't, strictly speaking, arise on the facts, because the medical team had sought consent and consent had been refused. But the question becomes, if a doctor or a medical team doesn't go to the family member and even offer the treatment to begin with, or doesn't give them the choice of whether the treatment will be given or withheld, what then? Is it a violation of the Act or not? Because it seems odd. It does seem to translate into an obligation to treat if you read the Healthcare Consent Act that way, and that is very much at odds with the common law, which I'm going to turn to towards the end of my talk, because the common law has recognized that doctors do not have a positive obligation to treat on demand of patient or family members. So, as I said, that question remains open. Now, because consent had been sought and the doctor had gone, the medical team had gone to the Consent and Capacity Board, the Consent and Capacity Board was charged with deciding whether the daughters in this case had complied with the Healthcare Consent Act in demanding that treatment be provided. And there are two parts to that test. The first test is whether there are any expressed wishes that are applicable to the particular treatment choice or the particular treatment that's in question. And in this case, the evidence was that Mrs. Holland had a general philosophy of life, and she expressed it as, where there's life, there's hope. And this was something that she, by the evidence, felt quite strongly about. And the question in the case was, is that good enough? Is that a a clear enough wish to say that therefore all medical treatment must be provided, that she would want life at any cost, no matter what impact to her dignity or the quality of her life that was remaining. And the board found that that wish was not specific enough, and if you look to the Conway case, which is referred to in the paper, you will see some of the factors that are considered in deciding whether a wish is applicable to the particular circumstances. But what is clear from the decision in the Holland case is that it doesn't need to be that you've gone through a laundry list of every possible circumstance that might arise with your substitute decision makers and said, well, if I have this disease, then I only want this, this, and this, but not other things, because of course that would be an unreasonable restriction to place. But it's not an easy question how strong, how specific those wishes have to be. But in this case, because the board's finding on this point wasn't unreasonable in the view of the Superior Court, the case wasn't overturned on that basis. And so again, it is an open question as to how specific expressed wishes will have to be in the context of end-of-life decision-making to be applicable under this heading. So the board and the Superior Court was then forced to turn to the best interest test, which was alluded to earlier. And there are essentially three factors to be considered under the best interest tests. The first relates to the first is that the board must consider the values and beliefs of the patient. The second is they have to go back and consider again those wishes that weren't specific enough under the first heading. Those come back into play under the second heading. So even if they weren't applicable the first time around, they still have some weight in the decision that the substitute makers and eventually the board have to make. And finally is the balancing of benefits and burdens associated with the treatment that's proposed, or in these circumstances, the treatment that's going to be either given or withheld, depending on what the decision is. The values and beliefs are almost always going to be within the domain of the family. It's generally not going to be something that the medical team has knowledge of, because typically they will be things that come from earlier points in the life. But it's not the end of the story. It's only one of the factors that has to be considered, and there's no real ranking provided to how important those are versus the other factors under the test. But what did come out of the Holland case, which hadn't been said perhaps explicitly before in another case, was that this test is very much a subjective test. It matters not if the evidence is that the patient was Roman Catholic and believed X. It matters not what the Roman Catholic Church says about the particular issue, about the end-of-life decision-making issues. If they are wildly incorrect as far as the Roman Catholic Church is concerned, even if they strongly held that view, that is sufficient under this test. It is a subjective test and not an objective one. And in fact, the Superior Court was quite critical of the board for considering evidence as to what the Roman Catholic Church's views were on end-of-life decision-making, because if those views weren't held by Mrs. Holland, in the Superior Court's view, that was irrelevant. What was relevant were her actual views, not the views of any particular faith or anything else. As with wishes, I've already talked about them a little bit, and in end-of-life decision-making, I think there will be considerable overlap between values and beliefs and wishes, because it is the type of issue that does intersect with morals and religions a considerable amount. But it is conceivable to think of a wish that might be applicable to a particular treatment relevant to end-of-life decision-making that wouldn't necessarily arise from the values and beliefs that someone held, although I've been hard-pressed to come up with a good example of one that would apply. And then you turn to the medical considerations, and this is where there was some considerable dispute about how you do this balancing of benefits and burdens. And one of the terms that's contained in that balancing part of the best interest tests is the well-being of the patient. And there was some considerable discussion about what that means, whether that means, or whether it's even possible for withdrawing or withholding life-sustaining treatment to be taking into account the well-being of a patient, because by necessity, it means that the person will die. And can those concepts coexist? And the appellant's position was that they couldn't coexist, that well-being could not encompass the idea of quality of life, of withdrawing treatment because the quality of life that was remaining was no longer worth continuing, that life had a value, and that's what well-being meant. Well-being had to include the notion of remaining alive. The respondents took the position that it was a broader concept than merely physical well-being, that it included concepts of quality of life, dignity, pain, and that was the view that eventually was adopted by the Superior Court and was consistent with an earlier case that had been decided by the Superior Court. And so we are now left with well-being being a very broad term that encompasses all of those considerations, including quality of life considerations. And I think that is an important ruling from the court on that point, because we have some guidance there. But what was very clear from what happened at the Superior Court, and this was the main reason why the decision was overturned, was because there was apparent confusion at the board about the difference between certain medical treatments that were being discussed at the board. There was discussion of CPR and ventilatory support, and at least in reading the decision of the Consent and Capacity Board, having not been at the board itself, it's clear that they had confused the two topics in their written reasons at least. And that was very concerning to the Superior Court. And I think it highlights the fact that it is imperative that the board understand the treatments that are being suggested, the consequences of not treating, the consequences of treating, that they understand the implications of all of those things. I don't have a lot of time left. I just want to turn quickly to some of the questions that are left outstanding. One, charter issues were raised in this case. They were not decided because the Superior Court decided to send it back to the board. If the medical team decided to go back to the board, they decided that it wasn't necessary to decide whether the Healthcare Consent Act is in compliance with the charter with respect to these. And the charter issues that are raised are Section 2 rights, which are religious rights, Section 7 rights, which are right to life, Section 15, which are equality rights, and how it impacts on people with disabilities such as an incapacity. And then will come the Section 1 analysis, and this is really the questions that are left open by this decision primarily relate to how these sorts of decisions interact with a publicly funded healthcare system. If the implication is that family members or patients can insist on particular treatment, how does that intersect with the fact that we have a publicly funded system, that if we will run out of money eventually. I mean, there is concern that we've run out of money already in this publicly funded system. But if funds are being expended on keeping individuals alive because the family members are demanding it, how does that impact on the rest of the healthcare system, including waiting lists for treatment for people who aren't inevitably going to die in the short term? And so these questions, I'm sure, will have to be decided in a subsequent case. There's no question that there are a number of issues that are left open by the case, not the least of which are the charter issues. There are also civil and criminal law issues that are left open by the case in terms of what the implications are in a civil lawsuit if treatment is withdrawn or withheld without the consent of the family, and how that intersects with the civil law. And these issues have been considered more fully in other areas of the law, in other areas, including the United Kingdom, which has quite clearly said, at common law, doctors cannot be forced to treat. They should come to court first before withdrawing treatment, but at the end of the day, the family members do not have the right to demand treatment. And I think it will be interesting to see how that case law gets carried over into the Canadian system when these issues are canvassed more fully.
Thanks. Okay, well, whenever I have the pleasure of working with Arthur, he always gives me this impossible task and then sets the bar really high. So each time it's a challenge to try and meet it. This time he says to me, I want you to explain your world to you guys. So I took a deep breath and I said, how long do we have for this kind of talk? So what I'm going to try and do is actually give you a little bit of information about what we're all about in the intensive care unit. Okay? Dispel some of the common myths that you might have seen on TV, and there are many. We're going to talk about how end-of-life issues are dealt with on the ground, okay, in terms of our daily practice, and it is an issue of daily practice for us. We're going to talk about the problems that we face, the shades of gray, and most of what we do is a shade of gray. I'm also going to give you a chance to sort of see how power is wielded by the medical teams that you will be up against if you're representing patients within the consent and capacity board setting or court setting. There are certain things that you guys need to know and questions that you can ask to know whether or not you're actually getting a fair deal here. And we're going to talk, finally, I'm going to end on the medical community's reaction to the Cullity decision in the Scardoni case. So what is an ICU? Has anybody been in an intensive care unit? Okay, a few. So an ICU is a place in the hospital that is highly specialized. It is the most specialized place in any hospital. Okay, we are extremely technical. Our goal is to provide supportive care for people suffering from an acute, life-threatening illness. We don't save their lives, no matter what the language is that you will hear. We provide support. Antibiotics will save their lives, not me. Okay? What do we mean by life support? Well, life support's a ventilator. That's a machine that we use to breathe for people. It's inotropes and vasopressors. These are drugs, you can think of them like adrenaline. These are drugs that are extremely powerful. They can't be given through a normal IV. They have to be given through what we call a central line, which is a big IV that goes into the veins under the clavicles, in the neck, or in your groin. Okay, these drugs work in one of two ways. They either increase the way that your heart beats, or they increase your blood vessel tone. So when your blood pressure falls, for whatever reason, we have the ability to counteract it. They are a place where dialysis is given. Now, this can be the standard dialysis that you may all be used to. It can also be something that we call CVVHD, which is dialysis that happens around the clock. And people go on this kind of dialysis if their blood pressure is too low, but their kidneys are failing, and we have to do something. So we've got to replace their kidneys somehow, but they can't tolerate the traditional mode that you're used to. When people say, yeah, I've been on dialysis for 5 years, we're talking different things. They're a place where we have all these fancy lines for monitoring, and I've given you definitions at the back of the tab and some idea of what's involved in terms of putting them in people, using them, this kind of thing. So you get a sense of exactly what's involved. The last one that I'm going to just touch on briefly is called ECMO. This is a word that will send a chill even through an intensivist's heart. With ECMO, it's called ECMO, but it's extracorporeal membrane oxygenation. We are your heart and we are your lung. Think of it as a bypass machine, but outside of hospital, outside of the OR. And it's very complicated to use, and usually people don't do well when they're on it. So the reason that you come to me would be you're in shock for whatever reason. This includes bad infection, you've got respiratory failure, cardiac failure, you've got definitions of this and the degrees of failure in the back of your handouts. If you have trauma, you've got some bleed into your brain, some major brain tumor, anything like that, so nasty situations. I thought I'd bring you some pictures just to show you what words can't often convey. So the picture on your left is an ECMO machine. The picture on your right is what a standard person would look like on life support. So you can see all of the IVs. Those are all the different drugs. The big machine at the back is the ventilator, and you can see, you can barely see the patient. Okay, the tools of the trade. So how do we put people on life support? It's also good to know. And I actually brought some so you can see it up close and personal if you're so inclined after this. So This is a laryngoscope. Okay, you see it illustrated on your thing. This is what we use to insert into somebody's mouth. We pull the jaw forward with this so we can see your windpipe. And then we put this plastic tube in, and it sits like this in your windpipe, and it comes up and it gets hooked up to the machine. We don't often dress this way to put this in, as shown in the picture. That is how we had to dress during SARS, for those of you who want a little bit of historical fact now, and I hope, quite frankly, I never have to get dressed like that again. Okay. But here's the question. We can do a lot of things. We can save people's lives now, or contribute to saving them, and we would have lost these people a very short time before. ICU medicine is one of the fastest evolving fields in medicine. We only came into being in the 1960s. Okay? And the questions that come up for us is, just because I can, should I? And here's what we end up dealing with. So there are these ideas of dignity. Now, the medical community doesn't have a great sense that, you have to have dignity or not dignity. That's really something that comes from outside. We just accept people as they come to us, and we don't sort of think, oh, is this dignified or not? These are people, we're there to care for them. Okay, for us, what comes into play a little bit more is quality of life, and we'll come and talk to that. So there's these ideas of suffering. Is there any value in suffering? Some people will say there is. It brings them closer to God. Okay? What's a benefit? What's a burden? How much is too much? When we're talking about small likelihood of survivals, how small is too small? In the ICU, we're there to beat odds. Okay? I will have people come to me with a 90% mortality rate, and I've got to deal with it. And we're going to talk about how that comes into play. What is quality of life, and how does it have any bearing? And then the last thing that we're all very conscious of, not perhaps when we deal with an individual patient, but sort of in the grand scheme of things, is this whole resource question that Erica alluded to. And the problems that we face is who decides and when. So here's the problem. Being at the forefront of medicine, ICU, what is appropriate treatment? What's going to work? We don't know sometimes until we try. Okay, we can dream up alternatives, but I can't tell you always, is this going to work or not? There are very few, what we call a gold standard in medicine, randomized controlled trials that exist. Okay, we're working within a scientific gray zone for the most part. And we have to become very comfortable with working within a level of uncertainty when the stakes cannot be any higher. Okay? So we have to also know ourselves. So there's these issues of judgment, of experience, of bias, because we all have our own personal beliefs, and of hope. And how do you deal with all of these things? I'll tell you, most of us don't go into this engaged in saying, oh yeah, they're going to die, let's hope for a peaceful death. We go, all right, let's see what we can do. And if we can't do anything, let's hope that we can at least make their death comfortable if it becomes clear that that's what we're going to be dealing with. In ICU, we have different scoring systems, okay? Apache is one of them. These are scoring systems that are there to try and guide us over how sick this person really is. Okay, what are their chances of survival? These are population studies. The higher the score, the worse off your chances are, okay? They don't apply to one individual, and that's the problem. So yeah, we can say, you know what, most people in this circumstance, it's not looking good, okay? But how you're gonna do, I don't know, all right? By the end of the day, though, a decision has to be made. And at times, I'll tell you, in the ICU, there's only room for one final decision maker. So you can take into things, we work as a team. At the end of the day, somebody has to come down and say, yes, no, here's what we're going to do. And I can't tell you how lonely, in the words of one of my colleagues I've quoted here, this feeling is. You feel extremely alone because you just hope to God that you've made the right choice. Now, we don't actually do suspense very well, so the good news is we know within a very brief period of time whether or not this may work. Okay? But it's difficult. And end-of-life decision-making is really part of our daily practice. Every time somebody comes to the ICU, we say, look we don't know. Things could change very quickly. You have to be prepared for these ups and downs. We try to give them an honest a picture as possible. Okay? But you can imagine the emotional turmoil, and I'm going to show you some slides to illustrate just what it would be like as a family member to walk in there. But here's where our struggles really begin. How do we assess capacity? Okay, somebody is on a ventilator. You can't talk with that tube in because it goes down through your vocal cords. Okay, so I've got to somehow manage to lip read. Or maybe you can write, maybe we can use a language board, maybe, but it's tough. And you can imagine the complexity of some of the decision makings and the consent processes that we need to go through, right? You want me to sit down and explain the ventilator and how I'm breathing for you. It's hard. It doesn't mean that everybody can't do it, but the task is very difficult, okay? Then we have to explain what we can potentially do and what we can't do. Okay, life support sounds like a great thing, maybe not. We have to put these decisions in the context of goals, values, and beliefs, and as Erica pointed out, we don't know that. So usually what we say to somebody, if we can't communicate with them directly and we're communicating with a substitute, we say, you know what, we really view this as a shared decision-making thing. We can tell you what we can do, what we can't do. What we can't tell you is who your mother is, what's important to her, okay, what matters to her. But we have to speak in very plain language and lay it all on the line. And most people don't talk, even within the medical field, in as plain a language as we will choose. We are not afraid to say die. We can't afford to be. That has to be clear. Okay? You can't say, do you want to come off the ventilator? And somebody say, yeah, but the only way off the ventilator is to die. Okay? That has to be crystal for them. We have to learn how to explain to substitutes how decisions need to be made. We heard some of the standards of that, so I'm not going to go over that, and I've talked a little bit about it. We have to deal with conflicts between family members, right? There are days when you feel like the umpire. It's like, why did I go to work? Yesterday morning, I had to deal with a situation of one family member who's stalking another, and there's an issue of should we get a restraining order? They don't teach you this stuff in medical school, okay? Like, oh boy. Is the decision-making voluntary? There's all different kinds of coercion, all different kinds of manipulation, of persuasion. Oh, Daddy, surely you want to be alive to see little Sally grow up, right? Of course you want this treatment. Yeah, of course he wants to go on life support. Okay? We have a very limited time frame for making these decisions, and that's very often the conversation that you hear that goes on between family members. Previously expressed wishes may be problematic if they're not applicable. Okay? We do a lot of things. None of them are all that pleasant. Okay? It's great if they work, but you have to go through stuff to get to that point. And how vague is too vague? Okay? And here's my biggest pet peeve for you guys. Okay? These advanced care planning, personal care, powers of attorney documents. In the event of an irreversible terminal illness, I do not want. I may not know if it's irreversible. I may not know if it's terminal. Some people will believe that this means I don't want to ever go to ICU. Okay? They could have pneumonia. I can treat pneumonia. Okay? I can make a difference there. That's not what this document says, but there's no discussion. Okay? They don't understand what they're saying yes or no to. And then we contribute to the problem. Here's the common language from the medical team. Do you want us to do everything? The opposite of everything is? Right? It conveys a message. Would you want to go on life support? There's no explanation of what that is. Okay, this is a plastic tube. It's put into your mouth. It sits in your windpipe. It's hooked up. They don't get any of that. Okay? There's been an overemphasis on the ethical notion of autonomy that's led to a real reluctance from the medical team to recommend a course of treatment, if not an outright failure. So what they end up doing is they present these options, and then they say, choose. How are you supposed to know what to do? ICU and CPR that's when we pound on your chest, and blow into your lungs and all the rest of it because your heart stopped, are increasingly always presented as an option. This is becoming the final common pathway of death in our society, is to pass through us and through me. And the ICU is really having an issue with this because that's not what we were meant to do as a group when we first formed and when we first developed this field. We're often only involved after a team has said he wants everything done, come and get him. Okay? We don't tend to get involved in the decision-making or the explanation piece. It's like, come pick him up. They're insisting on it. He's yours. Okay. Teams have unrealistic expectations of what we can do. The medical teams, the surgical teams. They have little appreciation of the burdens of treatment. Often they'll come to me and I won't see the medical team ever until they're discharged from me. Okay? And there's a very short time in the decision-making frame. So here's a patient. That's how his family knew him. That's how we knew him. This is how his family saw him the first time they walked into an ICU. This was a family who was operating as the power of attorney, substitute decision maker, however you want to think of them. How hard do you think their role is? Okay. It's a message that is one that needs to be remembered, because you can't convey the emotional toll that holds on them. I had to withdraw on a young boy who we couldn't save. We just could not treat this man's infection. Everything we tried failed. And his mother said to me, "How do I know he's not in there saying, 'Mommy, don't leave me'?" How do you talk to people about these things? Okay, this is a very common discussion. This is not one in a million. Okay, this is what we do every day. And here's some of the things. I mean, critically ill is sometimes equated to an imminent risk of death. That's true sometimes, but it's not true all the time. The course of illness is difficult to anticipate. Even though we can see some warning signs, we can't see all of them, and bad things happen quickly. CPR is not ICU care. This was the biggest problem with the board's language. They use cardiopulmonary resuscitation to encompass ICU care. In fact, the two need to be discussed separately, and we don't even do that with our patients. Okay, so there was a recent study a couple years ago in the New England Journal of Medicine, right? Our Bible, if you know anything about medicine. This is the quintessential place that you want to be published. Right? What these investigators did is they sat down, they watched TV. If I only knew, right? So they said that, they looked at survival rates after the heart stopped. Okay, when the heart stops, you are dead. Okay, so they looked at this. What are his resuscitation survival rates? Chicago Hope, ER, and I think, can't remember, one of the other ones. And the average survival rate is 80 to 95% on these shows. Not only that, but you never come and see me afterwards. And let me tell you, your heart stops, every single one of you will be coming to see me afterwards, okay? It's not realistic. But people go away with this sense that it's not so bad. Now, when we look at certain populations that we do have information on, patients with end-stage cancer, after bone marrow transplant, or the elderly who come into us from nursing homes, if their heart stops, they have a 1% chance of survival or less. And that doesn't mean survival intact, that just means alive with a heartbeat, okay? Now, when you're representing somebody, how will the medical team wield their power? What kind of shortcuts will they take? They'll use DNR, so do not resuscitate in the event of a cardiac arrest, to mean no admission to ICU under any circumstances. So the only option that will be presented is if your heart stops, you'll need ICU, you'll need resuscitation. You don't want to go there, do you? I mean, that's a nasty place. They won't talk about, you could need ICU if you get a really bad infection, if you have pneumonia, there are other reasons that people come to me, then I actually have a better chance of doing something with, okay? And they take an all or nothing approach. So you go to ICU, it's a one-way train ticket, and you're never getting off, right? And this is one of the biggest fear out there in the population. So they don't discuss a trial of therapy where we say, you know what, is this too much? Is it working? Is it not working? What length of time can we sort of guess that we would need to know a little bit one way or another? Okay? They use this language. So ICU is aggressive. Okay? It's heroic. I'll tell you, I don't feel like a hero most days. It's extraordinary treatment, okay? What kind of language and what message does that convey? And you'll even see it on the nursing home forms, okay? Level 1 care, comfort, you're gonna be wrapped in down pillows, everything's gonna be happy, happy, nice, you know. By the time you get to level 5 or level 4, depending on where that form stops, right, you will get aggressive care, full resuscitation, and be brought to hospital. Again, subtle language message, but it's definitely there, right? And the biggest beef that we have with these forms is like, for God's sakes, it's not like we're, you know, we try our best to give you drugs to make you comfortable. There are certain things that I can't take away. I can't take away the pain of suctioning. No matter how much I'd like to, I can't. It's just, there's no way to get there, to get pain relief there. And that's one of the most difficult parts. But I can try and make most of it bearable, okay? And when we look at what other options we have ancillary treatments that are not presented as options. So for example, somebody won't present dialysis. You know what, his kidneys are gone, that's it. Sorry, over, okay? Ask the question, what about, you know? And that's why, you know, hopefully you'll get a little bit from the information I left you. Then there's this final piece on futility. So what's futility in law? We have the same reaction in medicine, okay? Here's what it is for the Tolkien fans among us. Futility is the one ring, right? Every doctor loves futility. You don't have to offer it ethically or legally. You don't have to discuss it. The only problem is we don't have a clue of what it is. So there's all these different definitions. If it didn't work in the last 100 cases, it's futile. I haven't had 100 cases the same, and I'll tell you this, I may be young, but no doctor has, because they're all sort of different, okay? If they're not separated from life support or they're in a permanently unconscious state, it's also futile. Okay, I've got people who've been living with me on life support for 5 years now. Is it futile? I don't know, they enjoy playing card games. Now they play games that nobody else but them can understand, but that's okay. Okay, and when you see how it's broken down, one of this is quantitative futility in our literature and one is qualitative futility. And then you'll have people who say, you know what, we've got to build on this notion. We've got to, like, you know, put some limits in. And so if we have 2 doctors that sign off and say that this is futile, it makes it so. And you will find that there are hospitals with policies like this wherever you practice. Okay, and it's very important that you ask the question, what are your withholding, withdrawing policies? What are your admission to ICU policies? To get a sense of how much of this is going into play, because they think that policies are protective to legal challenges. But is there any consensus? Well, the Society of Critical Care Medicine in Canada tried to look at this issue because in a spirit of fairness, we wanted to try and get something on paper that would provide guidance. So we wouldn't have doctors sort of turning or pulling the plug, as you may hear it said, and others sort of continuing on. So of course, previously expresses wishes, you know, right up there. The question is are they really informed? We have people demanding treatment. We've heard some of that today, but we've also had people refusing treatment where we could actually make a real difference. And this is heartbreaking in both scenarios for us. And it takes a long time to explain. If the burdens are greater than the benefits, or if they're only serving to prolong the dying process, we would not advocate bringing somebody to see us. If doubt exists, institute the treatment and then reassess. Okay? Individual needs may lead to different decision-making on a case-by-case basis. You can refuse to admit a patient if they will not benefit or if it would harm another by precipitating a hasty discharge. I'll tell you, I get somebody knocking on the door, the first thing we do is we look at the ICU and we say, okay, who's good enough to leave? Okay, who can we send out so we can put this person in because they're too sick for us to move somewhere else? That's the kind of level that we're dealing with. No CPR does not mean no ICU, and we haven't got an obligation to offer care that's not in accordance with the standards of practice. The problem is the standards of practice are gray. For us, withholding is equal to withdrawing. If treatment is rejected and that rejection is informed, then that's fine. If it's not in the best interest, again, we would question it. If the treatment fails, you'll see a lot of these things are very similar. And if there's discord, the recommendation is that we continue. And this is a Canada-wide sort of statement, policy paper. But we're working in a changing world. So when we try and sit down and engage people in these very difficult decisions, all of a sudden, they've been coming there every single day, they disappear. They won't come into the hospital. There's been an increase in insistence and demands. You will do this. There's been threats. So we get verbally abused. Okay, there's been physical violence, punching, this kind of thing. We had one guy threaten to come in with a gun and shoot us. He was going to kill 20 of us. I don't have any idea where the 20 came from, but so he said. And I get pulled out of rounds dealing with a complicated case to be told that there is a situation. So I'm like, okay, what is this situation? And they're telling me this story, and I'm like, okay, they haven't been to, with us for some time, right? I mean, like this situation, this patient, we looked after them months ago. Like the ICU's moved since then, right? We can barely find our ways here, right? No problem, they'll never find us, right? That being said, we had to have the police in, we had to lock the place down, this kind of thing. And of course, the favorite threat, which some of my colleagues would say is even worse, is lawsuits. Okay, so Arthur asked me to comment on the recent interaction with the legal system, the Consent and Capacity Board experience. We are not taught how to approach this body. We go there without legal representation. From the CMPA point of view, the stakes are not felt to be high for a physician to appear before this board. And we don't have a set mechanism of dealing with this so that we have a lawyer who speaks your language. The formality of court is intimidating. We often fail to understand why a lawyer needs to be appointed by the public guardian and trustee to represent the patient. And in fact, the team's response to this is usually totally insulted. We're there for the good of that. Why do they need a lawyer? This kind of thing. Now, you can explain that to them and they'll all be fine, but that's the initial thing, and you're going to encounter it more as you go into the community hospitals. Lawyers often arrive without ID and demand access to the chart. Sorry, it's not going to happen, okay? Bring some ID with you is the one corollary that I would add, and then no problem. There's a lot of time commitment. That initial board hearing took 8 hours. It was the first weekend I had had off in 5. Okay, I was on my weekend off. I was there all day. I had to go back on call on Monday. That's not meant to be a sob story, but it's just to illustrate to you why some people won't take the time or even question a substitute. And they'll just go along with it because it's the easiest thing to do. The good thing about the Consent Capacity Board is that they're very responsive to our time limits, okay? But the biggest question that we have is, do they really know what we are talking about? There is nobody from ICU on this board. It's psychiatry. And with all due respect, the fields are different, okay? And there's a level of understanding and of technology that psychiatrists will not have any interaction with. The courts, all right. From the time that we went to the board to the time that this case was heard in court was October to the end of January, and we're talking beginning of October. For us, in this kind of situation and putting somebody through the treatments that we put through, this was an extremely long length of time. I know it's felt to be relatively fast for you guys, but remember my frame of reference, 5 minutes, I know what's going to happen, right? Don't ever put me in a suspenseful movie, it just doesn't work. The proper procedures, what cannot be submitted is a total mystery for us, okay? And it's very effort and time intensive, despite the efforts of our legal team to make it as painless as possible. The fundamental question that the medical teams will ask is it really worth it? So where are we left, and what's been the reaction to Scardoni? And this is not just my reaction, okay, just to make it clear. In the case, ICU was said to be equivalent to therapy for respiratory failure in the same way that antibiotic treatment is standard treatment for infection. This is such a simple reduction of what we do that we are awestruck. Okay, I know it likes to be black and white. I know it likes to be clear. I know it likes to be awestruck. Okay, it's just mind-boggling to us. With you have to really experience the ICU environment. For those of you who've been there, you'll have some sense of the level of noise, of intensity, and just to compare that to antibiotics is just such a simplistic reduction that it's incredible. Should a power of attorney be given greater deference than a substitute decision maker? Mrs. Holland had made the time to go out and actually physically appoint her daughters, sign off on a piece of paper, and make them power of attorney. Does this mean more? Should it mean more than if they had been appointed by rote or statute, right? As the law dictates. Don't know. Never has before. The origin of belief is not important. Rather, it is how it is internalized and how strongly it is held. Okay. I have, and I want all of you to know, because I expect you to act for me, an extremely strong belief that I will live forever. Okay, it came to me on my birthday a few weeks ago, as Erica knows. And, you know, it's not going to happen, right? We all die. And I use it as an extreme example, but here's the fundamental question for us. Where is the notion of reasonableness gone? We have reasonableness when it comes to disclosure for consent, this kind of thing. In terms of decision making, is there such a notion? Can it come into play? Quality of life was not to be given a huge lot of weight in some of the pronouncements, and you can see where the medical team is sort of getting with this when you read the judgments. One of the biggest criticisms of ICU is that we fell so in love with our own technology that we just kept it going no matter what the cost to that individual. We were going to pull them through this illness no matter what. And so when quality of life considerations re-entered ICU, when we became more aware of the limitations of what we could and couldn't do, this was felt to be a good thing. Okay, and so to decrease the weight, it seems to us to be putting us back about 30 years in terms of practice. And we're left with a sense that these are decisions that we wrestle with every day. It's the hardest part of what we do. It's the reason, in fact, that as staff, we only do a week at a time, because emotionally it is so draining. Yet we're left with a sense that when we're stuck, and we went through this process, and I'll say this with a very legitimate question, we were really concerned that where there's hope was just not sufficient to go through all of this, to be faced with the burdens of what we were going to inflict. And yet, is the court really there to help us face these decisions? How do we get there? We tried not to end up in court. We tried to have mediation. The family refused mediation. And, you know, was it the right path to go is sort of where we're left. Is there some other way of resolving these issues? And we don't have a good answer for that. We actually really need help with this, because this is becoming more and more of a question in our mind as we face more and more of these situations, as people live longer and live longer with more illnesses. And I'll end it there. Thank you.
Thank you. Thank you both very much. Please join me in thanking. We'll reconvene at 1:40. I look forward to seeing you all again this afternoon.